Hello everybody. My name is Dan Regard. I'm the founder and president, CEO of iDiscovery Solutions. We specialize in helping lawyers, judges, corporate counsel, and other individuals grapple with litigation challenges and investigations and solve those challenges with data. I'm here to talk to you about what we do and introduce you to something that we've coined fact crashing. So for today's purposes, I am a teacher, a speaker, an author, a special master, consultant, and testifier, but many of my clients come to me because they see me as a futurist, someone who has seen where we are today and where we're going. And where we're going is into a world rich with data. And my challenge is to help transform that data world into a beautiful landscape as you see before you now. And as a futurist, I'm often asked the question, what if? And my answer is the following. What if you could tap into the digital universe? What if you could replay any moment in time as a digital narrative? For the lawyers in the audience, what if you always knew who to depose and what to ask in advance? What if you could conduct litigation with zero emails? Well, first of all, I wouldn't use this picture for zero email litigation. According to the judges I speak to, this is the picture we should be using. It would be a celebration. I'm here to tell you, to comfort you, to promise you, all of these are the promise of big data. But what is big data? That's an overhyped, over-technical term. There is a definition for it, though. The 3 V's of big data. It is the variety of data sources we're dealing with, more variety than we've ever seen before. It is the velocity of the data. We're not collecting it once a year, once a month, but once a day, once an hour, once a minute, once a millisecond. And, as you can expect with the word big, it is the volume. The volume of data is enormous. And every day, scientists tell us we're creating 2.5 million bytes of data, which is an incredible concept. People ask me, how do you relate something that's digital to something physical? How big of a pile of data is that? Would it reach to the top of the Eiffel Tower? And the answer is, you really can't translate that cyber volume to a physical volume. But if you like the Eiffel Tower like I do, this really is a beautiful picture of the Eiffel Tower, isn't it? The reality is, not only do we have a lot of data today, there is a lot more coming. Why is that? Because of the advent and rollout of 5G. 5G isn't just a communications protocol. It's an ability to create more traffic, more devices, smaller devices, longer battery life, more frequent communications. Everything increases with 5G. Could you imagine having all the computers you have today and then being surrounded by 10 to 100 times more devices? What this translates to is more data. Devices that are collecting information, not on the things that we say, but on the things that we do. And in reality, it's the things that we do that really inform us for litigation and investigation purposes. If you had all that data in one place, what would it be worth? What value would it have? It would be without value. Data has no intrinsic value. But if you can convert it to patterns and insights and connections, it can have tremendous value. We know that because of the companies that have transformed the world through their ability to organize data. It has disrupted entire market sectors. As of right now, the largest retail company in the world needs no stores of brick and mortar. They work with data. The largest retrieval and research company in the world has no libraries, but Google dominates. The biggest transportation company in the world has no vehicles. They work with data. The largest research and encyclopedia company in the world does not sell encyclopedias. They organize data. The largest community building organization in the world has no rec centers. And the largest hospitality company in the world has no hotel rooms. They all deal with data. Now I see some shock, I see some concern in the audience. For you in the legal industry, let me reassure you, this will never affect the practice of law. Of course it will, and it already has. There are some outstanding cases we already have seen dealing with data. Let me tell you about the Fitbit case. The police came to investigate how did his fiancée die. He said someone had broken into their apartment, tied them up, tortured them, and then killed her. Her Fitbit told a different story. Debate is now under indictment for murder. The gentleman who said, I went to sleep and everyone in the house was still having a party, and some of my friends stayed late in the hot tub, and I don't know how he died. The police came and investigated the smart water meter that showed somebody using water at 2 a.m. sufficient, say the police, to wash off a crime scene. So data was helping solve that problem, and Bates is under indictment for murder. And then finally the gentleman who said, I was in my house, I smelled smoke, I called the fire department. They said, get out of the house. So I climbed out of a window and barely escaped with my life. Later, with a search warrant, data taken off of his pacemaker told a different story. He had been quite active before the fire and was later charged with arson and insurance fraud. So yes, data knows us better than we know ourselves. With that in mind, let me tell you a different story. We worked on a case involving home-based technical repair people. They drove vans from their homes, and we were asked to investigate, were they working before they clocked in, or were they not? Were they being compensated for all of their work, or were they not? To do that, I ended up talking to one of the managers, Mary. I want to introduce you to Mary. Mary, I want to talk to you about Henry. She said, I know Henry, I manage Henry. I've managed him for 5 years. Therefore, I know him inside out, and I have to tell you, says Mary, Henry is one of my top performers. I'll never forget that. One of my top performers, she said. Let me introduce you to Henry. I said, Mary, since you know Henry so well, did you know that he pads his time? That he makes every job that he works on seem like it took longer than it actually did? Did you know that Henry reroutes his invoices so he can go where he wants to in town, and you don't know where he actually is? She was getting fired up. I said, Mary, did you know that Henry has a second job? This is what the data told us. Mary was furious, but I remember what she said at the end of the conversation. Now I know why he drives a second car. Mary did not know Henry, but the data did. Rather than looking at Henry's data the traditional way as individual silos of data, we've developed a technique to integrate that data so it can all be examined together. And that integrated examination of the data really showed us what Henry's true day looked like. We gathered data from his Windows operating system. We gathered data from his information technology, operations, fleet management, finance, his personal detours, his time punches, and we integrated all that into one consolidated picture that allowed us to see what Henry was doing during the course of the day, and that was amazing. And then we programmed the system to let us know, was he following the story, the narrative that the plaintiffs had presented? Was he in fact checking his schedule for up to 30 minutes a day before he could leave his house? Was he preparing his vehicle and checking his inventory before he left the house? Did he have to commute 30 minutes to every project? Did he have to get there and clock in before he could start working? And is that when he got compensated? And it turned out that pattern was not fit by his data, or his data did not fit that pattern. The computer allowed us to identify those days that had anomalies. And this particular day came up where Henry, turns out, did not require 30 minutes to log in. He only required less than 10. And he logged in not before he started working, but after he started driving his vehicle for work. And he logged in not before he got to his first project, but after his first project was already completed. This was completely contrary to the entire narrative. We went on to find that they claimed he had no time for lunch. This day he had time, plenty of breaks for lunch. That his time had been padded. His vehicle was moving when he said he was working. I'm not an appliance repair person. I don't fix refrigerators, but I can guess it's pretty dangerous to fix a refrigerator from a moving van. His first invoice was in his driveway. He has no customers in his driveway. He had late punch-ins at the beginning of the day, late punch-ins at the end of the day, and he had this one gap of time in the middle where he kept going to what we referred to as his personal detour. We were never really sure what he was doing in his personal detour, but he went there a lot and he spent a lot of time there. He also was driving when he was checking his inventory, and contrary to his claims, did not work after hours. Other than these 18 problems, this was a perfect day for Henry. We found lots of days like this. Using the data, integrating it, comparing it to the narrative allowed us to understand, was Henry's narrative reliable or was it fabricated? In this case, it was a problem. We looked at it graphically. Henry ultimately on this day did visit all 7 of the job sites that he said he visited. The challenge was, did he really work 9.5 hours? And did he visit them in the way that he said that he did? And the answer is no, no, and no. The data showed us, even though he went to each of the sites in order, he took multiple detours and spent multiple minutes of personal detour time not on the clock, even though he charged his employer for that time. Ultimately, at the end of the day, Henry went to his same undisclosed personal detour 3 or 4 times on this day and did not work 9.5 hours, but rather worked less than 4 hours of time. When we showed this in mediation, the opposing side jumped up and down and said, anomaly, anomaly, this is not representative of every day. But Henry had been there 243 times in 6 months. Apparently it was representative of every day. Again, the data knows us better than we know ourselves. Now, we mentioned 0 email cases. This is not an anomaly. We are seeing an increase in cases where analysis of the structured data, the bits and bytes of the Internet of Things and our transactional systems collect, has been more informative than documents, emails, and text messages. Cases such as a banking call center, a tissue delivery service, an 11,000 member truck driver class action. All of these have allowed us to analyze small, medium, and large size cases with no emails being required or necessary at all. And when you think about it, it makes sense. How important is it to know what someone said they were doing on a given day? Pretty important. How much better is it to know what they were actually doing on that day? That is crucial. So if the data is so informative, what about data privacy? Well, data privacy is a big concern. Our rules of civil procedure allow us to investigate information that is already private. That is the essence of discovery. If it wasn't private, we wouldn't need to discover it. Data can actually be unsettling and uncomfortable for people because of the extreme quality and quantity of information it provides about personal actions. That's exactly why it's informative for litigation. But if you're concerned about data privacy, we do have rules in our discovery system to help protect for that. We also can target the scope of the data narrowed to the issues that are being investigated. And especially with documents like emails and text messages, we often work with the metadata, but not the content itself. We don't care what people said they were doing. We care when they were doing it, where they were, who they communicated with, rather than what they actually said. We also have the standard rules of discovery we should contend with. Is the information relevant? Is it proportionate? Is it prejudicial? And is it privileged? If we can answer these questions, we can move forward and treat data like any other category of evidence for civil procedure and handling purposes. You may be asking yourself now, how can I do this? And we have an answer for you. We've been helping hundreds of attorneys in hundreds of cases deal with these data issues. And to do that, we've developed a program called fact crashing, our own methodology. Fact crashing is an early focus on the ambient contextual data in a case to accelerate and resolve the investigation for the entire case. It's really a portmanteau, a combination of two phrases, the first being fact, which refers to the digital elements, the digital facts that make up a history or a case, and crashing, which is a construction term for the acceleration of one phase of a project for the benefit of the entire project. Fact crashing is our approach to using facts to accelerate investigations. And that methodology has principles that we've written out to benefit you, your team, and your clients. The fact crashing principles: number one, data is evidence and is discoverable. Number two, data should be addressed early. Number three, frame your case issues as data-centric issues. Number four, identify and prioritize your sources of data. Number five, data may be subject to preservation, privacy, and security obligations. Number six, data reliability starts with proper collection. Number seven, data understanding is required for proper analysis. Number eight, use data to shape other discovery. And number nine, use data to work toward early resolution. Let's get into it. Data trails. What, where, when, who, how, and why. If I was to ask you if there was any evidence that you had attended this seminar today, what would your answer be? I know what my answer would be, that there was a plethora, an abundance of emails, invitations, Zoom logs, your browser history, phone activity, your phone GPS of where you were, the fact that you weren't moving for the duration of the seminar, your operating system logs, LinkedIn posts, comments, your Apple Watch activity, notes that you took, probably digitally, your home Wi-Fi if that's where you were enjoying the content of this seminar, and of course cell phone tower data telling us where your phone was located, and by extension, likely where you were located. There is a plethora or an abundance of data that tells us exactly what happened. I don't even need to ask you. The data will tell me the truth. Let me give you an example of an actual case for call center overtime. We worked on a case where they claimed it took 20 to 25 minutes to go from the security desk to the working desk, where people clock in and start getting compensated for their, we call it non-exempt, you would call it hourly employment position. But when we looked at the data and pulled data from multiple data sources, including when they arrived in the building, when they logged into the Wi-Fi, when they went through security, when they badged through the elevator, when they logged onto the system, when they made their first phone call response, we found it was a 2.5 minute average. A very different story from the human recollection or human perception, perhaps. I suppose sometimes when you're doing something you don't want to do, it seems like it takes forever. And when you're doing something you really enjoy, it seems like it's over before you can snap your fingers. Data tells us exactly how long those durations lasted. And one thing we found when we work in cases like this is not only can we analyze, was the employee compensated for every minute that they worked, we can also answer the opposite question. Did they work for every minute that they were compensated? A very different perspective. We used data to work on a Me Too investigation. This was a claim of tragic sexual harassment. But by examining the cell phones, the travel plans, financial expenditures, we were able to show that the two individuals accused of this terrible behavior were in fact not even in that geography when the actions allegedly took place. It was a fabrication. The data helped really exonerate the individuals who were wrongfully accused. Just as in other cases, I'm sure, the data can help establish what really happened when those allegations are correct. Other cases we've worked on that have been data-centric: 40,000 class members for toxic tort, 11,000 members for a truck driving compensation case, 450,000 employees claiming employment status as opposed to 1099 status. A multi-system medical device data history case. A single wrongful death case. A case where a single named plaintiff was involved in the delivery of specialty tissue for medical services. A large antitrust case spanning the United States and several international countries. A 700+ entity healthcare and insurance claims linkage connecting Medicare claims with insurance coverage. And a 1 billion record entity resolution case involving data breaches. None of these required emails. All of these relied on data. Some of the fact crashing best practices. Work in abundance, not in scarcity. Consider structured and unstructured data. This is not just about data. I'm not saying we never rely on emails anymore. I'm suggesting that emails may no longer be the low-hanging fruit, and that our access to structured data for fact crashing purposes can be faster, cheaper, and more informative, so that when we turn our attention to emails, we get more bang for the buck. We spend less time reading things we don't need to read and more time reading information that is actually informative on the investigation. Another best practice is always remember the white space. We don't just analyze the data that's there. We ask ourselves, if XYZ narrative was true, what additional data should be there and why is it not? Sometimes the absence of data can be just as informative as the data itself. Focus on gathering the data, but also controlling the narrative. The more information that you have for your team, the better prepared you are for every engagement. And every interaction is a negotiation, whether it's a meet and confer, whether it's a hearing, whether it's a deposition, whether it's a trial. By being better prepared with the data, you can control that narrative. Ensure the essentials. Make sure that you have a system for gathering and sharing and working on this data. Make sure that you have the right tools to integrate the data and bring it together and compile it. Make sure that you have the ability to share data with the other side, because what you rely upon in most discovery, you end up sharing with the other side and vice versa. And make sure that you have the systems in place to ensure the integrity of the data you're working with. And a final best practice is start early. Many times we find the data that we want to investigate is not actually in the control of you or your client. You may need discovery requests, you may need subpoenas, and those can take time. In certain IP investigations, Internet Protocol addresses, sometimes we need 2, 3, or 4 subpoenas to get from one source to the next, to get to the ultimate source of a posting on a Reddit board, the certain disclosure of information, or the source of an email that is critical or crucial to your litigation. So start early. Some observations we've learned from fact crashing. Number 1, data is the new email. Number 2, context is the new tar. Number 3, deposition is the new trial. I have a client who says his depositions are no longer inquiries, they are inquisitions. Knowing more up front as he walks into the deposition allows him not to ask about facts that might have occurred in the past, but rather use that time to verify, is this witness even credible? Number 4, proportionality is difficult, but data actually helps us solve it, because in a world of asymmetric discovery where you have large defendants and individual plaintiffs, the classic belief is that the defendant has all of the data and has all the obligations for discovery, and the plaintiff has no data and no obligations. But when you start seeing the world through data goggles, you see that nobody is data poor. Everybody has data. And when everyone has data, everyone has discovery obligations. And when everyone has discovery obligations, proportionality suddenly becomes a real conversation, because, as we say, everyone has skin in the game. So based on that information, you may be asking yourself, How can I deal with this? And the answer is, we have developed a fact crashing methodology to allow you to apply these same principles for yourself, your team, your litigations, and your investigations. These are the 9 principles of fact crashing. Let's go through each one of them. Principle number 1, data is evidence and is discoverable. Under the Federal Rules of Civil Procedure, we know that data compilations are within the scope of discovery. And under the Federal Rules of Evidence, specifically 902, 13, and 14, we have new amendments in the last 10 years that allow us to address the authenticity of data gathered from electronic and computerized sources. These are records that are generated or records that are compiled in the ordinary course of business. And we have the quintessential guide to dealing with e-discovery, the Sedona Principles, which also have an extension called the Database Principles that address the discoverability of data. Principle number 2, data should be addressed early. For many of us, this will entail new processes, multiple layers of data, potential reliance on third-party sources for data that are not under the control of either the plaintiffs or the defendants, and at the same time can have the biggest impact for downstream case issues. So, because it's more complicated, more parties to engage with, and bigger impact, you should start early. Number 3, frame your case issues as data-centric inquiries. All cases have claims and defenses. We learned this in law school. You learn about the elements of a tort. Each one of these can be translated into data-specific measurements, almost like the SMART goals that you learned growing up. How can you make it specific, measurable, actionable, concrete, tangible? If you can do this with your case-centric issues, you can translate a case into something that can be measured and affected with data. I'll give you an example. We worked on an elder care home case. Were the residents receiving adequate care? And we worked with the doctors and the lawyers to define what might be a measurement of adequate care. What was the ratio of staff to residents? How often were individual rooms visited? What was the quantity of medication distributed on a daily basis? What was the cadence of that distribution? Once we measured these out, we could then measure through the data what those numbers were and contrast that to a baseline to show this met, exceeded, or failed to meet the standard of care. Number 4, identify, qualify, and prioritize your data sources. There are multiple ways that we can use to identify data sources. I'm going to show you 9 of them that we use most frequently. Document the 5 aspects of documentation, 5 A's of accessibility for qualifying, and 5 C's of reliability for prioritizing your data. What we find is, in fact, when you start looking at the world through data goggles, there are so many sources of data. The problem is not finding data sources. The problem is limiting yourself to the ones that are most impactful from a cost-benefit perspective, i.e., identify them, qualify them, and then decide which ones you're going to go after immediately, and maybe the others later or never. Prioritize them. The 9 methods for identifying data sources. We use this on a regular basis. Number 1, first and foremost, what is your experience? This is a wage and hour case. This is a toxic tort case. This is a medical device liability case. You've worked on these cases before. You probably start with an idea of where data might reside that is impactful. Number 2, though, review the pleadings. Someone took the time to interview the plaintiffs, form the allegations, lay out a fact history. That will help inform where the data might be. Do your independent research. Conduct employee interviews. Make a site visit. You would be surprised how many attorneys don't actually go on site to investigate the location where an allegation was made. We've done this for OSHA claims and driver claims and other physical plant facility issues. And by walking around through a site visit, we see things with our data goggles that you would otherwise be oblivious to, perhaps, if you had never visited. We conduct ride-alongs with employees. What does the day in the life of an employee look like? Go with them through their steps. Where do they log in? what systems do they use, what software do they use, etc. Number 7, we conduct tabletop exercises where other individuals sit around a table and virtually walk through an employee's day. You represent the company, you represent the facility, you represent the employee, I'll represent the municipality, and let's see what systems are in place that register data through the different actions of the day. Conduct a SIPOC analysis, which is a very simple exercise to deconstruct the workflow of systems, inputs, processes, outputs, and customers. Or conduct formal discovery. Whether it's a direct request for production or a Rule 45 subpoena, you can request information, and the infamous 30B6 can be very informative on understanding which systems are in place and how they operate. As you work through these systems, think of the 5 aspects of documentation. What were the data requirements or obligations? What is the process for collecting data? How are systems being tested? How is the accuracy of the data being validated? And how is the data being reported or actually consumed? As you consider reliability and you qualify your data, think of the 5 A's of accessibility. Number 1, availability. Does the data actually exist? Number 2, accessibility. Can you get to the data? I know the NSA has satellite data, I just can't get to it. Affordability. If you can get to it, what will that access cost? Applicability. If you actually get it, do you have the tools to analyze it? And finally, admissibility. Will that data make it into court? Will it fall in that category of reasonably calculated to lead to discoverable information or admissible evidence, or will it itself be admissible? As you start to prioritize your data, think of the 5 C's of reliability. Catalyst. What caused that data to be recorded in the first place? Capture. Was it recorded because a device recorded it or because somebody typed it in, which of course can be fraught with human error? What is the content? Is it a structured, very controlled, defined data, or is it unstructured, free-form text? Is it an email content, or is it the very controlled timestamp of that email? Control. Does the party who you're asking the data from have direct, indirect, or no impact on how that data is maintained? Do you trust data that comes from me more or less than you trust data that comes from my cell phone carrier? Do you trust that more or less than you trust the data that comes from the person I was communicating with as opposed to my sources? And finally, correlated. Can this data be correlated with any other sources? Should it be correlated? Are the other sources missing? Every communication has 2 sides. Every event can be recorded by multiple devices. If those devices don't record the same event, or they record the event in different ways, there may be a reliability issue with your data, or at least your narrative. Think about the scarcity, abundance, and sufficiency of data. As lawyers, we are trained through school and through the legal system that all data is scarce. There's not enough of it. Well, that's a traditional perspective. But in a data world, we have the opposite. Not only do we have sufficient data, we often have a vast overabundance of data. Our problem is not finding a few elements of data, but rather sifting through millions of elements of data to determine those that we need versus those that we don't need. So it is not a problem of scarcity, it is a problem of abundance. And for abundance, we need to prioritize our data sources as to what's proportionate and, yes, what is sufficient. It is the true embodiment of an economic principle of minimalization, maximum benefit, minimum cost. And now we see economics creeping into the first tangible definition of proportionality that we've grappled with in the law for so long. Here's an abundance exercise. How many data trails exist to show that you participated in this seminar, in this event? Well, we have the emails, invitations, the log of the webinar itself, your browser history, your phone activity, or lack thereof, your phone GPS, which may show that you didn't move for an hour, or you got up and left, your operating system logs, LinkedIn posts, LinkedIn comments, your Apple Watch connectivity, the notes you took, probably electronically, your home Wi-Fi system, the cell tower data, webinar chats, the list goes on and on. We could think of 20, 30, 40 different sources of data that must agree in their data footprint to you participating in this seminar today. So I was presenting this information to a group of esteemed lawyers, and one of them said, "You don't know that I was here." And I said, "No, but your phone knows that you were here." And he said, "I'm going to throw my phone away." I said, "The data will tell me about that too." So we can't destroy the data, we can't hide from the data, and we can't change the data, especially when it's not in our own control. And given enough time and resources, we've been able to vet out any story to either show that it was correct or that it was misrepresented. Principle number 5. Yes, data is subject to preservation and protection obligations. As we become more aware of the possible effect of data on resolving disputes, it expands our obligation to preserve that data. Data is more persistent, we find, than ad hoc communications. But any data over time can be subject to chaos, which means it doesn't go away, but it becomes incrementally or exponentially more expensive to put it back into a structured environment for analysis. So my advice to my clients always is, if you think data is going to be involved in your case, take steps early to preserve it and collect it. And protect it. We have an increasing number of obligations in regulations around financial data, health data, customer data, fill in the blank, credit card transaction data. All of these requirements add to heightened degrees of security that we need to implement when we collect data and preserve it. Yes, we're collecting it for a reason, for a legal purpose. However, it still reflects the actions and lives of real individuals. As far as the privacy aspects of data, yes, data contains private information, but that's the exact purpose of discovery. As I like to say, civil discovery is an institutional exception to data privacy, retention, and confidentiality, if you use the right mechanisms. Some methods of protecting data. You're collecting a bunch of data, and now you want to protect it. How do you do that? Well, you can get a protective order. You can have a data neutral appointed by the court or the parties. You can focus on the European principle of data minimization. Only deal with the minimum amount of data you need for the issue you're dealing with. You can look at regionalization. Only move data as far as you need to aggregate it and analyze it. If you can keep European data in Europe, keep it in Europe. If you can keep Texas data in Texas, keep it in Texas. Encryption. Makes sense, but you can have encryption by transmission and encryption at rest. We suggest both. Pseudo-anonymization. That's replacing some of the key aspects of data with alternative names that you can reverse later if you need to. True anonymization. That's where you replace it and you can't reverse it. And then aggregation. I'm not going to tell you about the individual actions of 1,000 lawyers, but I will tell you about the aggregate actions of those 1,000 lawyers. Principle number 6. Data reliability starts with proper collection. It's hard to analyze something when you don't know that it was reliable in the way that you collected it. This is a process-driven solution. It should be well documented. It should be subject to quality control, and you should migrate your data before you start minimizing it, which is another way of saying when we work on large data collections, we like to collect it first and filter it second. That way, if we need to refilter it, we don't have to disrupt the business to collect it again. Principle number 7, data understanding is required for proper analysis. If you don't understand the data, how can you analyze it? You can get a bunch of addresses out of a business system, and if you don't know if those are the customers or the vendors or the suppliers, you can't really analyze those addresses. It might be a combination of all three. Profiling the data that you've collected, verifying and validating the data you've collected, looking at training, conducting interviews, or testing the data is the right step toward getting up that learning curve of what does this data represent. Data has a fundamental different cost profile than written words. So structured data behaves differently than unstructured data. One of those aspects is the learning curve. We all have used email for at least a generation. We have all of these preconceived notions of how it works, how it behaves, and what we're going to get from it. So the learning curve is low, but the cost of dealing with is linear. Structured data is the opposite. For many of us, we work with data systems that we've never seen before. It's our first time. So the learning curve is high, especially for the first record. But once we've gotten past that first record, because they are structured, all of the other records tend to be similar. So that means a system with 1 billion emails takes 1 billion efforts to analyze each one of them. But a system with 1 billion structured records takes a bigger effort for the first record and almost no effort for the rest of the 999,999,999 records. The learning curve is very different. Principle number 8, use your data to shape other discovery. As we work through structured data, we can use that to inform us as to where we need to look in the unstructured data. We can use it to inform us as to what the scope might need to be for other aspects of discovery. Many times we see discovery requests, give us any and all emails related to XYZ. Well, that's really not what you need. What you need are those emails related to these 15 events. And if I can use structured data, buys and sales of equities, for example, to inform me as to when those 15 events took place, we can then tailor our email discovery to just those 15 date ranges, just those 15 events. It turns out to be much more efficient, much more cost-effective, and much more impactful. Principle number 9, use data to work toward early resolution. Turns out, as you use data to work through the issues in a case, the data can help resolve some, if not all, of the issues. And as you do that and remove those from contention, you can narrow down the issues that are truly in dispute, narrow down where you're spending your time, your resources, and your efforts, and move toward resolution faster. Which brings us to the final principle. Use data to work toward early resolution. Not only narrowing your scope of discovery, but also working toward closure. I've seen lawyers effectively use early case assessment in depositions that led to an immediate termination of litigation. They knew more going in, and they used the deposition to present their case to the, not the witness, but opposing counsel. So whether you're dealing with merits issues, damages, witness credibility, class cohesiveness, discovery compliance, or depositions in general, data can be a very effective tool to move toward early resolution. These are the principles of our fact crashing methodology. I give them to you. Use them to your advantage. Use them for early success in your cases. Use them to own the data, control the narrative, and win your cases. And if this seminar were not sufficient to inform you as to the things that we're talking about, great news. We've just published a book called Fact Crashing. At the end of the seminar, you'll have information on how to get your own copy of that. You can find it on Amazon. You can find it in great bookstores around the world. Fact Crashing is the in-depth analysis of our fact crashing methodology to allow you, your clients, and your colleagues to use these principles to help you resolve disputes in a timely and cost-effective manner. So, we've had a lot to say today. In conclusion, let me summarize. No one is data poor. Get an early start if you're going to deal with data. And if you want superior outcomes, think about accelerated resolution, reduced cost of discovery, strategic advantage. Any of these, use fact crashing in your case. And if you're one of the judges in our audience today, I urge you, when someone comes to you with requests related to structured data, approve of it. And if they don't come to you with a request for structured data, think about recommending it. So we've had a lot to talk about today, a lot of new information, a lot of new ideas and concepts. You might be thinking, this sounds important, but this is a problem for tomorrow, not a problem for today. Well, I'll share with you a quote from one of my favorite authors, William Gibson, a science fiction forward thinker a true mastermind of technology. He coined the phrase cyberspace. William Gibson tells us, the future is already here. It's just not evenly distributed. Take this information, go forth, be victorious in your cases, and I'll see you on the battlefield of data. As I said, here's the information. Get your own copy of our fact crashing methodology. Download a copy of the book. It'll give you more in-depth examples of everything we talked about today and give you additional background for how these principles came into being, how we've matured them over time, how they've been applied in hundreds of cases around the world, and how they could be effective in your cases. As you can tell, I'm very passionate about these issues. This is what iDS works on every single day. We've worked on hundreds of cases like this. And I don't have enough time in one seminar to share with you the 30 years of experience we have with this. However, here is our contact information. If you have any questions, any thoughts, you want to continue the dialogue, let's dig into it, give us a call. Our team of consultative experts are here to help you on any case at any time.